Welcome to the Grow Your Law Firm podcast, brought to you by PILMA. This podcast helps lead lawyers to more growth, profit, and freedom. Here is your legal marketing expert and host, Ken Hardison.
Hey, Grow Your Law Firm listeners. This is Gracie Howes from PILMA, and I'm excited to pop on today and share with you a special invitation. If you're serious about growing your law firm this year, you need to be at PILMA Super Summit, happening May 20th through 23rd in San Antonio, Texas. For more than a decade, we have brought together the best minds in legal marketing, management, intake, and operations, and now AI for one purpose: helping law firm leaders grow and scale their law firms. Attendees leave our conference with a real plan, actionable tools, strategies, and resources, not a brain clouded with conflicting messages and ideas. This isn't a conference where you sit and listen to theory all day. You will hear from real attorneys who are sharing what's working and what's not working when it comes to marketing and managing their 8-figure law firms. You'll be in breakout sessions built specifically for your role: COOs, marketing directors, firm owners, managing partners, leadership teams, so the right people get the right strategies. You'll have the opportunity to workshop real challenges, ask questions of seasoned marketers and leadership experts, and walk away knowing exactly what to implement and who owns it when you get back. We're going deep on AI, and not in a conceptual way. In our AI breakout, you'll have your laptop open, building, testing, and creating alongside experts. At our recent AI for PI event, attendees literally built their own custom AI tools during one of our breakout sessions. That is the level of hands-on that we are about. You'll also get to connect with attorneys and law firm owners who are scaling fast, sharing what's working right now, and building relationships that last long after the conference ends. The networking is intentional, the content is actionable, and the agenda is packed. If you want clarity, momentum, and strategy you can actually execute, join us at Super Summit this May in San Antonio. Registration is open now. Check the link in the show notes and secure your spot today.
Hey, it's Jenna, Membership Growth Advisor with PILMA. If you're serious about growing your law firm this year, don't miss your chance to book a free law firm growth strategy session with me. We'll break down what's holding you back, identify the biggest opportunities in your firm, and map out the next steps to accelerate your growth. No pressure, just real strategy and direction tailored to you. Click the link in the show notes to schedule your free session.
Well, hello, everyone, and welcome to another episode of Grow Your Law Firm. And today we have the pleasure and honor of having Alex Proctor with us at cybersecurity. And thank you for being here today, Alex.
Oh, absolutely. Thanks for having me, Ken.
Yeah. And so tell a little bit about the company and what you do, and then we're going to get right into it. We're going to talk about something that's very important that we don't think about a lot.
Oh, fantastic. Yeah. So my company is called Captain Compliance, and the world that we operate in is the world of privacy, and especially privacy when it comes to online privacy and the privacy of your website as a business. It's a really interesting world right now because there are all sorts of new privacy laws being passed across the country. There's just been a flurry of activity over the past few years. And the requirements from those laws are really leaving, businesses and law firms and everybody else somewhat in a state of scrambling to try to adjust to these new laws. But the really wild thing is that at the same time as all these new state level laws have come out, there's also a major wave in private litigation about website tracking and other, privacy related aspects of how companies run their websites. So that leads to what Captain Compliance does, which is, we provide tools to make it easier for businesses to meet their privacy obligations, whether that's having really great privacy notice content or really great consent mechanisms on their website to ensure that they're giving visitors choices and they're honoring them. That's the sort of thing that we do is help support companies in their needs in that area.
Is that something like, I see a lot of times when you go on a website or go into something, a sales page, you'll say terms, you got to click something that says terms and conditions. We agree with it. I mean, I see Meta does. I see everybody does this all the time. And of course, nobody reads it because it's about 30, 40 pages.
You hit every single nail on the head there. That is exactly the area that we're talking about here. And the interesting thing is that style of notice and consent, it really came out of Europe. So back, almost 10 years ago at this point, Europe passed this landmark privacy law. Businesses had to start doing this on their website. They had to start putting up, new levels of notice, new requirements and so on. And we were somewhat insulated from that in the US for quite a while. But especially since California sort of led the way here in the States, and then we've had like 18 other states follow suit. It's that's the sort of thing that has become very important to US businesses as well. It's kind of a funny thing because I don't think anybody loves the model. Like nobody, even my own company, it's like I don't want to be having to interact with a cookie notice on every website that I visit or have to be, reading long privacy notices. But that's kind of the challenge of the area that we in is there are these obligations and there are some things we can do to make it better for the website visitor too. So I can share
Yeah, I
some of
mean,
that as
yeah,
well.
yeah,
Yeah.
I'm seeing it all the time. It pops up when I go to a web. But I see certain times it says accept or reject, and then I see sometimes it says accept or conditions. I mean, it's got some other language. It's not simply a accept all or reject all. It's got something in between. I don't know. You know what I'm talking about?
Oh, totally. Yeah, you can oftentimes specify granular preferences. So if you don't want to say accept everything or reject everything, you can usually go in and like maybe you might want to turn off, marketing and targeting trackers that are doing targeted advertising, but you might want to leave, let's say, like performance and analytics active. So a lot of the times the websites will give you those options in the hopes that you won't turn off everything. The privacy conscious side of me says, I'm always clicking decline on those sorts of pop-ups. So from the personal privacy perspective, I really recommend that. But the most of the time, the website, the objective is you can't really do things to deceive people into accepting or try to guide them to accept because the states consider that to be deceptive. But what they will do sometimes is, make it very easy to make a choice, either accept or reject, and they tend to hope that they get the maximum opt-in rate so that the website analytics can continue to run.
And so I'm guessing every lawyer out there, if you're not doing this, I bet your web is searchable in California, even if you're in Atlanta, right?
Yeah, that wasn't always the case, and the reason that's the case now is from the two angles. So the first angle is with these state laws. The state laws don't explicitly say you need to have a consent banner pop up on the front page of your website. But what they do say is that if somebody sends you an automated signal to opt out of targeted advertising, like using their browser or a browser extension, you have to honor it. And so effectively, the only way to do that is to have a consent technology in place. So that is a requirement for these state laws. The other side of it is there's this really wild trend of certain law firms and individuals and plaintiffs attorneys using wiretapping laws from the 1960s that were written before the internet was at least created in its modern form. The typical allegation is that the websites are performing some sort of wiretapping of somebody's browser session on the website. And so they use the old laws because they have a private right of action, and then they can create these cases. They're called SEPA cases in California, although there's other states with similar laws. And there, one of the things that the courts tend to look for is, did you give the website visitor a chance to opt out of tracking? And some of the courts even want to see that up front. So they don't want any tracking to happen until somebody says that it's okay. So there's all kinds of nuances there because the courts are split on how to interpret these 1960s laws in the modern internet. But that also is another area where the consent banners really come in for companies and help protect them.
Yeah, I remember when I set up the film web 16 years ago, I knew I had to have some terms. I really wasn't thinking about the tracking. I was thinking more about other things at that time because I had a membership. I wanted to market. You know what I'm saying? And now the big deal is people want to get your phone number, cell number, and then send you text. So what's the law? What's the present law state of that, Alex? As far as
Oh yeah, that's an
yeah,
awesome.
but you can text people and offer them to opt out, or do you have to get their permission before you send them the first one, and then still give them a chance?
Yeah,
Maybe
the laws about around outbound marketing, they're probably even more advanced than some of these website tracking laws because the laws around the outbound marketing have been around for a lot longer. The main themes there continue to be explicit opt-in, or in certain cases, especially with email, giving an option with every single marketing email that you send that someone has a way to opt out. You need to do things like provide an actual address. there's like a whole laundry list of requirements, and they're slightly different for phone, email, and text. But that is an area where companies should definitely be very careful because the laws are very well established about outbound marketing and compliance there.
So, is any lawyer? I mean, this looks like to me a really big this website stuff would be a gold mine for somebody to bring a class action against some company that doesn't do it, and then try to get all the people that have visited their site, file a class action, and then you discover, you find out everybody that's been to them, and then you go market to those people, and then you file this big ass lawsuit against whoever the company is for not having this. I mean, is that happening?
Yeah, that's exactly what's happening under SEPA in California. And the reason is because the wiretapping law from the 60s and that private right of action, it allows for what I believe is $2,500 per incident, if you will. But within the context of a class action, the incident could just be one web visitor going to the site and supposedly, being wiretapped. So it can just stack up, unbelievably quickly. And that's why these large class actions are a big deal. The other trend is that, and I know this just because, we hear this a lot from prospects and we can kind of get a view behind the curtain. There are individuals and just different entities sending out, in bulk, probably what amounts to thousands of letters per week to companies who, may or may not have everything quite right on their website. And they're using very interesting techniques to allege that an unauthorized tracking is occurring. So one of the ones that everybody should know about is it's nothing to do with what you might think about like cookie tracking or anything like that. It's that what will happen is they will go on a website and find the search bar. Not every website has a search bar, but maybe, a third of them do. And they'll go on the search bar and they'll search for their own name. So this would be like me. I'm Alex. I'm going on the website. I'm searching for Alex Proctor in the search bar of some random law firm or website. And then what they do is they go look at the network traffic that happens after that search. And if the website takes that search content, Alex Proctor, turns it into a URL, and then sends it off to a third-party analytics provider like Google Analytics or some other provider, they will then use that to allege that an unauthorized wiretap occurred. So the reason that's so interesting is most of the time when you think about, privacy, you're thinking about the cookies that you're putting on somebody's browser. It's a little bit more obviously invasive to privacy, but they found a creative way of using these search bars and searching for their own name, which, of course, nothing's going to come up for their own name, but because it creates a URL with the term included and shares it with a third party, that's how they're having some success with these letters. So there's all kinds of creative approaches.
Any of these cases, I mean, have they gone to appellate courts? Are they holding up? I mean, these cases, or that most people just settle? They don't want the exposure.
I think it's a total mix. There are certainly some that get escalated up. There's a really interesting one that I'm tracking right now. It's potentially going all the way to the Supreme Court with something called the Video Privacy Protection Act. There's a case with the NBA, like the sports league. The allegation there was that someone went to NBA.com, watched some videos on maybe some basketball highlights or something, and then information about those viewing habits, quotations about what they were viewing, was shared with third parties, which I don't know what the third parties were. Let's just say maybe they were like Google Analytics, likely something like that. And then the allegation was that this is another old law. This is from the 1980s. It's a law that protects video privacy. So like it was originally for if you go to Blockbuster or some video rental store, the law was intended to protect your rental history. Well, now it's being applied to basketball highlights on NBA.com. And so that one's been, it's several courts have seen that one, but it's the same thing with these other wiretapping lawsuits. A lot of companies do settle early just because maybe that's the risk decision that they want to make. They don't want to, let it go. It's just a real mix. And then in other cases, what often happens is that the companies will, after receiving one of those letters, is when they will prioritize putting consent technology on their website. It's kind of a funny thing that we see a lot is we'll talk to, different organizations about the risks and, we'll explain them. And then, for one reason or another, maybe it's not prioritized, but a lot of the times we've actually talked to companies and then they've received some sort of letter after the fact and we've talked to them again. So all sorts of different paths that companies are taking.
So what's involved in compliance? I mean, You don't have it. You have to comply with so many things. I mean, well, I guess you guys got a checklist or something. I hope.
Yeah, it's very challenging because like nobody, unless you're someone like myself, it's too much for any one person to track. It's just too much. And so what that means is that the key is to focus on the high level themes that will protect you across a wide variety of privacy risks. And the way that I like to think of it is that there's really two. The top one that I would say is having a really strong privacy notice. This can cover you in a lot of different ways. And the beauty of it is you don't necessarily need technology to have a great privacy notice. You don't need to spend on some technology or invest in it because you can just simply dedicate attention to your notice. It's something that most companies struggle with because it's hard to do. You know, I look at these all day long, and a lot of the times I'm finding notices that haven't been updated in like 6 or 7 years, 8 years sometimes, or whatnot. And the reality is that at minimum they should be updated every year to account for internal changes that are happening within your own company, the ways that you've changed processing data, and also to account for the requirements of the different state laws that now require you to share information about their consumer rights in your notice. So just keeping on top of the notice goes a really long way. The downside is if you don't do this and you have some outdated notice while you've changed the way that you process personal data, is you can get into deceptive territory. So like the FTC has long made this a really big deal, going after unfair or deceptive privacy notice content, where you say you're doing one thing but you're not. Like that's almost worse than not having a notice in the first place, is if you're deceiving people through your notice. So huge deal. Obviously, there are ways that you can use technology to enrich your notice. Like that's what my company does, but that's the number one. And then the other one is with having some sort of consent technology or mechanism on the site. And that's what we were talking about a little bit earlier with the pop-ups. There's different ways to put these in place. They can be more or less prominent on the website. You know, some will put them right front and center. Some will put them in the footer, and there's different conditions that you might take either of those paths. But the absolute key is that you give your website visitors a way to opt out of tracking if they want. There's different things you have to do on top of that, but like at the very core, at least give somebody a path to opt out of tracking if they want to do so. And if you combine that with having a strong privacy notice, I don't want to quantify it, but your risk will be significantly reduced as opposed to if you didn't have both of those things.
Yeah, yeah, I agree with you because I know sometimes I get all these emails because I signed something for somebody else and I didn't read all the print and I had to unsubscribe, and some of them are they just unsubscribe you. And some of them, they get in there and they make it real complicated. I mean, I got a law degree and I'm still sitting there, I have to take 5 minutes to figure out what they're trying to, how do I unsubscribe from this? Because they make it almost like they're trying to trick you. You know what I'm saying? And I think those companies, if they do that on what you're talking about, themselves a big ass lawsuit. Because, if somebody wants to subscribe, just let them unsubscribe. If somebody don't want to be tracked, just don't track them. I mean,
Yeah, exactly. So you raised an important point. You make me think I know there's some companies in my email inbox that I have unsubscribed from like 5 times, and I'm still getting emails. So that's definitely a problem. When it comes to website tracking, the key thing is that this is like one of the real world problems is a lot of companies will put one of these, banners on their site and they will feel good. It seems that they've done the right thing. But the complexity is that a lot of the times these technologies don't even work. So I hate to bring the bad news, but like if you go and you interact with some of these banners and let's say you click reject and say, I don't want to be tracked. If you actually look in your browser, there's a way to do it through like your developer tool menu and you actually look at the tracking that's happening. A lot of the time, like usually over 50% of the time when I test this, the tracking is still occurring. So this is like the next wave of what, the states and litigators are going after is it's kind of like on the deceptive theme again. If you've told your visitor that you've given them this opportunity to opt out and they think they've opted out, but you're still tracking them, that's a very bad territory to be in. So that's another thing that I would recommend is that maybe you feel like, you've got your consent technology in place, check it out and see, really do some testing on it to make sure that it's blocking everything that it needs to when somebody wants to stop tracking, because if it doesn't, that's a pretty risky position to be in. And that happens all the time.
so does your company, like if you I hire you, will you go in there and make sure that it's compliant, that it will block, that it won't crack?
Yeah, exactly. So, there's a lot of different things that we care about when we install our tech. Like a lot of the times there's little things like we want to make sure it looks nice on the site and that it's customized to look good. But like at the end of the day, none of that's really even nearly as important as making sure that it's actually doing what it says it's doing behind the scenes. So that
Yeah.
is the number one priority. Yeah.
And so when you do all this, do you have to shut down the person's website for a day or two, or can you do it and let everybody get it along?
Oh, yeah, great question. Typically for this sort of technology, that's not necessary, but it is a really good idea if you're going to install something like this, because you're introducing functionality to stop certain aspects of the website. They are marketing aspects and targeted advertising aspects. It should be done in a very, careful way. So usually at a controlled time with testing happening, just to make sure that there's no unintended blocking happening for maybe something that's essential to the website at the time that it's deployed. So usually no outage, but there is, certainly certain care that's given at the time that it's deployed to make sure that the website works as it needs to.
Anything that I didn't ask you that I should ask you, or something that our viewers or our listeners don't know, that it's all about?
No, those are great questions. I think I've covered all the kind of like the modern hot topics when it comes to web tracking. Just know that there's companies out there like mine who can help, and that you don't have to be an expert. We can help take that off your shoulders, because realistically, like I said, none of us is going to be the expert on privacy. There's just too much happening, both with the private litigation and the state laws. But that's why we exist, and we're here to help if anybody needs it.
So if somebody wants to get up with you, Alex, or your company, what's the best way to do it?
Yeah, the best way is to go to captaincompliance.com, because that's kind of like the path to any sort of whatever you need. But I also always encourage anybody to reach out to me personally. You can look me up on LinkedIn. My name's Alex Proctor. You can email me. I'm alex@captaincompliance.com. I love getting in touch, and anything you need, I'm happy to connect with anybody that way as well.
Listen, I appreciate it. This is something that I think all our listeners and viewers need to know about. Always something you got to worry about.
Thank you so much, Ken.
Till next time, this is Ken Hardison, dedicated to your success.
You have been listening to the Grow Your Law Firm podcast, the podcast that leads lawyers to more growth, profit, and freedom. Go to growyourlawfirm.com to find more ways to market and manage your law firm. Please leave us a rating and review wherever you listen to your podcasts.